Our second judge for today's session is Honorable Mr. Justice Amit Sharma, sitting Judge, Delhi High Court. Your Lordship completed his graduation in BA History Honours from St. Stephen's College in the year 1992 and LLB from Campus Law Center in the year 1995, and thereafter he started his practice in criminal side before the Trial Court and High Court of Delhi. Lordship was appointed as an additional public prosecutor before the High Court of Delhi in the year 2007. Lordship was also appointed as the special public prosecutor for National Investigation in the year 2010. Delhi, Lordship as judge for Delhi High Court in the month of June 2020. We are delighted to have your Lordship's presence with us today. Thank you, sir.
Thank you. Morning all.
Good morning, Justice Sharma.
Good morning, Mr. Singh.
Thank you. I think the organizers, you need to do something. I believe there's a lot of loss of voice. The connectivity may be issue, and I'm not sure if the participants can really deal with that. So I'll request just take care of that part.
Yeah, it's breaking.
I think members of contesting team can hear that.
Yes, sir. There are difficulties in hearing.
All right. Okay.
I apologize. There is a connectivity program, and we are joining in just a couple of seconds. Thank you.
I am so sorry for the technical glitch. Am I audible now?
Marginally better, but there's lag in between. I believe that you have your internet problem. Possibly you can try switch off your camera, then voice may be available to everyone.
Am I audible, sir?
Yes.
May I proceed with your introduction, sir? Am I audible, sir, now?
Yes, you're audible.
Thank you, sir. Thank you for bearing with me. Shall I proceed with your introduction, sir?
Please go ahead.
Our third judge for today's session is Shri Balbir Singh, sir, Additional Solicitor General for India, Supreme Court. Sir is a first-generation lawyer and one of the youngest lawyers to be designated as a senior advocate by the Honorable High Court of Delhi. Sir has vast experience in the area of corporate commercial tax, trade, antitrust, technology, and regulatory litigation. He has experience of participating and representing in domestic and international dispute resolution proceedings before the arbitral tribunals. He has represented the Income Tax Department and the Competition Commission of India in leading cases of treaty disputes, transfer pricing, cartel, abuse of dominance, etc., before the High Courts and Supreme Court of India. His deep understanding of regulatory regime and commercial issues in sectors like telecom, intellectual property, technology, electricity, infrastructure are his strengths besides the knowledge of law. So we are thankful to you for your presence and for your encouragement to the students.
Thank you very much for having me being as a member of this Moot competition. And all the best to all the participants.
Thank you, sir, very much, sir. I shall now read the rules for the teams. Today in the semi-final rounds, we have 45 minutes allocated to each team. Each speaker can speak up to 30 minutes maximum and can reserve 5 minutes for rebuttal. We shall all maintain anonymity, and we have two teams. Team 101 is arguing for the prosecution, and team 155 is arguing for the defense. With the permission of honorable judges, I would like to start the session.
Yes, please.
Grateful. Team 101, speaker 1 may start.
Am I audible?
Yes, go ahead.
May I please the court, the counsel is appearing on behalf of the prosecution in the case of State versus Rakesh Kumar and others. Honorable court has the jurisdiction under section 177 of CRPC to preside over the matter. Is the honorable bench entrusted to know a brief summary of facts of the case?
Yes, please proceed.
Much obliged. Based on the complaint of informant Kajal, also prosecution witness 2, FIR was lodged on 2nd of February 2022. The informant around 8:30 a.m. had gone to her terrace to hang wet clothes, where she heard an intense crying of a girl coming from the vacant plot covered with dense bushes in front of her house. Alarmed by the sound, she immediately called her husband, that is prosecution witness 3, on the terrace. Both prosecution witness 2 and 3 saw 4 persons physically and sexually abusing a girl, and one of them holding a pistol. They called some of their neighbors, prosecution witness 4 and 5, namely Shri Santosh Kumar and Amit Kumar, respectively, to accompany them to the place of occurrence. Reaching the plot, they saw 4 persons, that is accused number 1, Rakesh Kumar, 2, Anuj Kumar, 3, Anil Kumar, and 4, Ajay Kumar, who reside in the same locality as them. Daunted by the presence of prosecution witness 2, 3, 4, and 5, in pursuance of fleeing from the scene, accused 1, Rakesh Kumar, had fired a gunshot at them. However, in the midst of galloping an assail, the pistol fell down from his hand and was picked up by Ajay Kumar, that is accused number 4, and he therefore tugged it in his waist. Subsequently, they all fled from the incident on 2 motorbikes. Thereupon, prosecution witness 2, 3, 4, and 5 rushed to the girl who was crying inconsolably and bleeding from her private parts. On being asked about the whereabouts of the incident, she wasn't in the state to answer any questions. Therefore, police was informed promptly and complaint was registered under section 34, 120B, 361, 376B of IPC, 6 and 8 of POCSO Act, 25 and 27 of Arms Act, and 18 and 23 of JJ Act. Honorable Court, I'll be dealing with the charges under section 370-60A of IPC, read with 120B and section 34, and section 361 and 363, read with 120B and 34. Now that the honorable bench is well versed with the facts of the case, the counsel seeks permission to proceed with the arguments for the charges framed.
Just one clarification. The victim also
Please.
belonged to the same locality?
Please, Your Honor.
Where is it stated?
Honorable Court, it's stated in the FIR and the charge sheet along with the details about her name, age, residential area.
Okay. Thank you.
May the council proceed?
Yes, please.
Much obliged, Honorable Court. Honorable Court, the child rape cases are the cases of worst form of lust for sex, where children of tender age are not even spared in the pursuit of sexual pleasure. There cannot be anything more obscene, diabolical, and barbaric than this. Honorable Court, in the case at hand, allegations against the accused persons are that they committed rape on the prosecutrix on 2nd of Feb 2022 at about 8:30 a.m. at a vacant plot in Zerdar Enclave, New Delhi. Prosecutrix was en route to her school when accused number 1, that is Rakesh Kumar, forcefully took her to the vacant plot on his motorbike. Meanwhile, accused number 2, 3, and 4, that is Anuj Kumar, Anil Kumar, and Ajay Kumar, were already standing and waiting there. Honorable Court, the essence of criminal conspiracy is the agreement to do an illegal act, and mere proof of such an agreement is sufficient to establish criminal conspiracy. And in the present case, the agreement to commit the offense can be foreseen from the arrangement set forth by the accused persons. Mens rea of conspiracy is well established along with the evidence of actus reus. The agreement can be inferred from the circumstances and conduct of the accused persons. Proceeding further with the charge of criminal conspiracy under Section 120B of IPC, the council wants to cite the case of Muhammad Usman, Muhammad Hussain Masniar, and another versus the state of Maharashtra, where the Supreme Court held that for an offense under Section 120B, the prosecution need not necessarily prove that the perpetrators expressly agreed to do or caused to be done the illegal act. The agreement may be proved by necessity implication. Honorable Court, in the present case, the circumstances before the commission of crime, during, and after the occurrence have to be considered to decide the complicity of the accused. The location of offense was primarily conceded, and the same can be inferred since Rakesh Kumar, that is accused number 1, implemented the conspiracy by bringing the prosecutrix at that previously agreed location, where accused 2, 3, and 4 were already standing and waiting. After the neighbors got alarmed and started to approach the vacant plot, one accused Rakesh Kumar fired a gunshot at them, and subsequently they all fled on their 2 motorbikes. Honorable Court, for the charge under Section 376D of IPC, the council requests the Honorable Court to please refer to the page number 32 of the charge sheet, where the statement of prosecutrix is given, which is made to the Honorable Metropolitan Magistrate under Section 164 of CRPC. That, and I quote, "As what I remember, one Rakesh Kumar stayed near my house and forcefully took me to a vacant street where other 3 accused persons, namely Anuj Kumar, Anil Kumar, Ajay Kumar, resident of the same locality in which I reside, were standing. Thereafter, Rakesh Kumar had pointed the gun on my forehead, and thereupon all the 4 raped me. Anuj Kumar holding the legs of mine, and he tried to tear the clothes. Anil Kumar was holding the hands of mine and pressing the mouth of mine so that I cannot make noise, and Rakesh Kumar and Ajay Kumar was in course of raping me. When some residents came near me, I was crying in pain and bleeding from my private parts. When residents asked me about what happened to you, I was not in the state to answer any questions." Honorable Court, prosecutrix statement under Section 161 of CRPC is also very similar with Section 164 of CRPC. The prosecutrix has been consistent throughout her statement under Section 164 and 161 respectively about the accused persons committing rape on her and the manner in which it was committed. Honorable Court, it is pertinent to consider here that there is no fixed age to be competent witness, and in the present case, the prosecutrix is the most reliable witness. Further, as a matter of fact, the eyewitnesses or prosecution witness 2, 3, 4, and 5, while recording of their statements under Section 161 of CRPC, have clearly mentioned the girl bleeding from her private parts when they found her, and that she was crying inconsolably. As per the Section 59 of Evidence Act, all facts except the contents of documents may be proved by oral evidence. The counsel affirms that the statement of the victim in the present case is reliable, trustworthy, and that she is a competent witness under Section 118 of Indian Evidence Act, and the same shall be proven by the counsel. Honorable Metropolitan Magistrate had put some questions to her before recording her statement under Section 164 of CRPC. Prosecutrix answers to those questions satisfied her mental, physical capacity as a witness, which has also been affirmed by the Honorable Metropolitan Magistrate. Therefore, the facts, evidence, and circumstances of the case emerge as to the effect that statement of the prosecutrix ipso facto is found to be worthy of credence, reliability, and requires no corroboration. Over and above that, it has been held by Honorable Supreme Court in the case of Phool Singh versus State of Madhya Pradesh that the conviction can be recorded on the sole testimony of the prosecutrix if her evidence inspires confidence and is absence of circumstances which militate against her veracity. In regard with implication of Section 34, the Council wants to rely on the case of Ibra Kanda versus Emperor, where it was held that common intention means the mens rea, guilty mind is necessary to constitute the offence that has been committed, and the present case exemplary suits the condition of Section 34. In view of the facts of the case, it ipso facto appears that the accused persons had pre-planned the wrongful act to commit rape on the prosecutrix, which can be further corroborated with the allocation of tasks between the accused persons. The acts committed by the different confederates in criminal action may be different. However, all must in one way or the other participate or engage in the criminal enterprise and must be in furtherance of common intention. Honorable Court, it was a pre-planned rape on an innocent girl who was on her way to the school on the morning of 2nd of Feb at around 8 a.m. Continuing with the charge, Honorable Court, it is submitted that victim was medically examined the same day with a MLC number 62/22 dated 2nd of Feb, and the report confirmed rape. Further, her swab test was taken and sent for forensic examination on the same day as well. Moreover, the MLIR, that is the Medical Legal Injury Register, which is maintained in the hospital to register entries, the state in which the victim was brought, and the primary conclusion of examination has been attached with the charge sheet, which states her name, age, reason why she was brought, and the primary conclusion. Honorable Court, it is contended that MLIR has asserted the injury on the victim by confirming the hymen torn and abrasions found on the breasts of the victim. Albeit the MLIR denies any history of physical assault, it shall be construed that abrasions found on the breast of the victim form the part of sexual assault and indicates her resistance towards the offense of rape. Moreover, the hymen torn corroborates the statement of the prosecutrix and eyewitnesses that she was bleeding from her private parts and constructs penetration by the accused persons. Honorable Court, the prosecution counsel understands that MLIR is not a substantive piece of evidence. However, in corroboration with the statement of prosecutrix, it does constitute prime evidence against accused persons. Further, in support of the sole testimony of the victim, the council wants to cite the case of Om Prakash versus State of UP, where the validity of sole testimony has been dealt with. It was held by the Honorable Court that it is a settled law that the victim of sexual assault is not treated as accomplice, and as such, her evidence does not necessarily require corroboration from any other evidence. Nevertheless, Honorable Supreme Court has laid down in Abdul Saeed versus State of Madhya Pradesh that where a witness to the occurrence has himself been injured in the incident, the testimony of such a witness is generally considered to be very reliable, as he or she is a witness that comes with a bulletin guarantee of his presence at the scene of the crime and is unlikely to spare his actual assailants in order to falsely implicate someone. Therefore, convincing evidence is required to discredit an injured witness. Honorable Court, the gravity of offense committed by the accused persons cannot be overlooked due to minor contradictions. The council, relying upon the state of Punjab versus Gurmeet Singh, wants to remind the court that no self-respecting woman would come forward in the court thus to make a humiliating statement against her honor, such as is involved in the commission of rape on her. Imagine the trauma she has to go through. Even when the law is sensitive towards rape victims, our society is clearly not. And in the hand, the prosecutrix's age is just 15 years. Honorable Court, the council further seeks permission to proceed with the charges under Section 361 and 363 of IPC.
Tell me something in the statement which she makes under Section 164 CRPC. The prosecutor states that this Rakesh Kumar, one of the persons who has been accused, he stayed near her house. So does she say anything that she knew him personally? He was her friend, or what was the relation, and or did she know the other persons who are the accused in this matter?
Please, Honorable Court, all she knew was that they were resident of the same locality in which she resides. There's no past history or personal history between them or the other three accused persons.
She does not know them personally at all?
No, Your Honor. Honorable Court, the Council seeks permission to proceed with the charges under Section 361 and
Yes, please.
365. Much obliged. Under Section 361 and 363 of IPC, the Council would like Court's attention towards the state of affairs or the paradigm in which offence was committed. In the present case, the offence committed by the accused had not been committed on the spur of the moment, where on the spur of the moment his lust overpowered his reasoning capacity and he committed the offence. Rather, it was a pre-planned offence where for the accomplishment of predetermined motive, accused kidnapped the victim and forcefully took her to a secluded place, that is the vacant plot, where other accused persons were already standing. Honorable Court, as per the commission of rape narrated by the prosecutrix, where one person held her hands and suppressed her mouth, other held her legs, further the third person committed rape on her, and the whole act was committed while keeping her hostage on gunpoint. Honorable Court, it is a well-established rule and has been stated in various cases that Section 34 must be read with Section 33 of the Code, which clarifies that an act includes a series of acts. Therefore, different acts may be committed by different members of a group, but still form part of a single criminal enterprise with common design. The most important ingredient of the section of kidnapping is the act of taking away or enticing away a minor or a person of unsound mind from keeping of the lawful guardian. In the present case, the fact of taking away can be proven by the fact that prosecutrix was found in the vacant plot with 4 people physically and sexually abusing her and indicates ipso facto that she was kidnapped with the motive of raping her and further corroborates the allegation of kidnapping. Unless contrary is proven by the defense counsel as to why accused persons were found in the vacant plot with the prosecutrix, the facts, circumstances, and evidence on record finds the charge of kidnapping plausible. Honorable Court, the Apex Court observed in the case of Moniram Hazarika v. State of Assam that if accused played some role at any stage by which either solicited or persuaded the minor to abandon the legal guardianship, it would be sufficient to hold such person guilty of kidnapping. Further, it is contended that prosecutrix was helpless in the present case. She was rapaciously kidnapped and was ferociously raped on gunpoint. The victim girl couldn't have possibly raised an alarm. The Apex Court held in the case of State of UP versus Chotilar that the absence of alarm by victim at the public place cannot lead to an inference that she had willingly accompanied the accused. These circumstances make her a submissive victim, and that does not mean that she was inclined and willing to have sexual intercourse with the accused persons. Concluding my arguments under IPC, the counsel wants to profess that a victim of sexual aggression would rather suffer silently than to falsely implicate someone. Therefore, any statement of rape is an extremely humiliating experience for women and shall be considered with utmost sensitivity. Honorable Court, the counsel would now request your co-counsel to please proceed with the further arguments.
The council seeks permission to continue with the ongoing argument. Much obliged, Your Honor. Honorable Court, I would be dealing with the charges under POCSO, Juvenile Justice, and Arms Act respectively. But before proceeding with the arguments, Council would like to reiterate that case is still at stage where charges are to be framed by the Honorable Session Court, and at this stage, mini trial should be avoided. Prosecution just has to establish a prima facie case which casts suspicion on the accused, thus providing court with the sufficient material to sustain the charges. Your Honor, material to establish prima facie case depend on facts of each case. However, the credibility and truthfulness of available material is not decided at stage of charge. It is well settled that when there is evidence indicating strong suspicion against the accused, the trial court will be justified in framing charge and granting an opportunity to the prosecution to bring on record the entire evidence for the purpose of trial. Considering these principles, prosecution would like to place relevant material and arguments to sustain charges under POCSO, Juvenile Justice Act, and Arms Act. The argument presented under POCSO is threefold. Firstly, Your Honor, the counsel deems it pertinent to satisfy the conditions of sections 6 and 8 consecutively, to assert the age of victim, competency of victim, and the alleged aggravated penetrative sexual assault. It is submitted that the Honorable Metropolitan Magistrate under Section 164 of the CRPC made sure to ask prosecutrix name, age, educational qualification, and her voluntariness to give the statement. These statements serve as an inference of confirmation of age of the victim. Under Section 118 of the Evidence Act, a child witness is a competent witness provided that she is able to understand the questions put to her and give rational answers to such questions. If the particular child who has appeared in the witness box is intelligent enough to be able to understand as to what evidence he was giving and able to understand the questions and able to give rational answers, there is no infirmity in acting upon the evidence of a child witness. Moreover, the Honorable Metropolitan Magistrate herself has confirmed that witness is competent to get her statement recorded and no external pressure or coercion has been used against her to get her statement recorded. Honorable Court, it is needless to say that if it's completely clear by the appearances of the victim that she is a child, then without delay further inquiry can be begun with. It is only when there are reasonable doubts in regard with the age of the victim, her age can be determined with documentary evidence, medical evidence, or ossification test. Therefore, in the present case, there has not been any contradiction related to the age of the victim, and even the Honorable Metropolitan Magistrate was satisfied with it. Your Honors, besides Section 165 of Indian Evidence Act lays down provision of judge's power to put questions or order production. The age of prosecutrix is 15 years at the time of occurrence of event, and questions put by the Honorable Metropolitan Magistrate before recording the statement of victim under Section 164 of the CRPC satisfies the age and competence of the victim to make her statement considered and not influenced. Continuing, the greatest reliability in the case is the statement of the minor victim. The absence of MLC report must not be a reason to acquit accused persons, especially when it is not denied but is due in the Honorable Court. MLR confirms injury in the form of abrasions on the breast of the victim and hymen torn. In Radu versus State of MP, it was held that bruises, abrasions, scratches on victim are indicative of struggle that she does to defend herself and support sexual assault. Prosecutrix has alleged in a statement given to Honorable Magistrate and Police Officer that she was raped by Rakesh Kumar, Anuj Kumar, Anil Kumar, and Ajay Kumar on gunpoint. Besides, she has also been consistent about the course and manner of rape. Moreover, eyewitnesses have been apparent about the victim bleeding from her private parts, and when they found her, which can be corroborated by the hymen torn found in the MLIR, it is well established law that to constitute an offense punishable under Section 376 IPC and Section 6 of the POCSO Act, penetration is sufficient and it is not necessary that semen needs to be essentially present. In the present case, hymen torn can be constituted in consequence of penetration due to which victim was bleeding from her private parts. The Supreme Court in the case of Attorney General for India versus Satish and another has clarified that Section 7 of the POCSO Act would cover both direct and indirect contact, that is, irrespective of whether there was skin-to-skin contact or not, an offense under this section would be constituted. The intention of the offender to touch a child inappropriately is enough to attract the provisions of this section. Intention of the accused persons to rape the victim can be implied prima facie from their conduct. Your Honor, what other reason might there be to bring the victim on a vacant plot? A fact of effective conspiracy to kidnap and bring her to the vacant plot and thereafter commit rape on her establishes clearly the sexual intent of the accused person. Most important is the applicability of presumption of Section 29 of the POCSO. In S. Suresh versus State of Tamil Nadu, the accused was convicted under Section 6 of the POCSO Act and he had not rebutted the presumption of Section 29. Therefore, the court observed that the rebuttable presumption also proved the guilt of the accused unless the defense is able to rebut the presumption as to why he took the prosecutrix to a different place. Sexual intent can be inferred by the actions of accused persons, keeping prosecutrix hostage on gunpoint while raping her. Under Section 29, when a person is charged under the POCSO, he is presumed to have committed the offense. Similarly, Section 30 presumes that a person charged under the Act had the culpable mental state necessary to commit the offense. Your Honor, secondly, it is apposite to recapitulate the law on the sufficiency of the statement of child victim in convicting an accused. In Dattu Ramrao and others versus State of Maharashtra, the Supreme Court held that the conviction on the evidence of the child witness is permissible if the witness is found competent and testimony is trustworthy. The council asserts that the statement of prosecutrix is sufficient to affirm the charge under section 6 and 8 of the POCSO Act, even in the absence of medical evidence. Honorable Court Justice Krishna Iyer has observed in the case of Rafik versus State that a murderer kills the body, but a rapist kills the soul. And in the present case, prosecutrix is just 15 years old minor when the incident took place. She has whole life ahead. In the case of Bharvat Bhoginbhai Hirchivai versus State of Gujarat, dealing with the uncorroborated testimony of a victim of sexual assault, the apex court held that in the Indian setting, refusal to act on the testimony of a victim of sexual assault in the absence of corroboration as a rule is adding insult to her injury. Why should the evidence of the girl or the women who complains of rape or sexual molestation be viewed with doubtful spectacles, Your Honor? Proceeding further, Section 7 or the Doctrine of Inductive Logic of the Indian Evidence Act ordains that if any fact related to the occasion, cause, or effect led to the circumstances in which that thing occurred, or it provided an opportunity for the occurrence of that thing, then those facts will be relevant. In the last scene theory also, the person who was last present with the victim would have a reasonable opportunity to commit the crime. As per the statement of prosecutrix under section 164 CRPC and statement of prosecution witness 2, 3, 4, and 5, it is clear that the victim was last seen with the alleged accused persons of the present case. Prosecution witness 1, 2, 3, 4, and 5 have also recognized the perpetrators as the resident of the same locality. It has been established through catena of judgment that the doctrine of last seen if proved shifts the burden of proof onto the accused, placing on him the onus to explain how the incident occurred and what happened to the victim who was last seen with them. Failure on the part of the accused to furnish any explanation in this regard, as in the case on hand, or furnishing false explanation would give rise to the strong presumption against him and in favor of his guilt, and would provide an additional link in the chain of circumstances. On that said, Honorable Court, the Council would like to prompt towards the apprehension of the accused Rakesh Kumar, who is a juvenile. The Council requests the Honorable Court to please refer to the page number 11 of the charge sheet, where decision of the Juvenile Justice Board is given. The amendment in the Juvenile Justice Act in 2015 has allowed children between the ages of 16 to 18 to face the trial as an adult if they are accused of a heinous crime. However, it has a requisite of preliminary assessment. In consequence, an assessment was conducted under Section 15 of the Juvenile Justice Act 2015, and order was passed in furtherance directing to treat him as an adult. Section 18(3) of the Juvenile Justice Act 2015 confers power to the board, where the board, after preliminary assessment under Section 15, can pass an order that there is need for trial of the said child as an adult. The board, after the preliminary inquiry as contemplated under Section 15, conducted an assessment of accused and felt that there is a need for trial of the juvenile, Rakesh Kumar, as an adult, then by giving reasons to the effect that the accused juvenile is between the age of 16 and 18 years, and he was mentally and physically competent to commit such an offense, and he was able to understand the consequences of the offense and also the circumstances in which he has committed the offense, directing him to be tried as adult. Lastly, in the case of Nipun Saxena versus Union of India, it is observed by this court that a minor who is subjected to sexual abuse needs to be protected even more than a major victim, because a major victim, being an adult, may still be able to withstand the social ostracization and mental harassment meted out by the society, but a minor victim will find it difficult to do so. Most crimes against minor victims are not even reported as very often. Therefore, no leniency can be shown to an accused who has committed the offenses under POCSO Act 2012, and particularly when the same is proved by the adequate evidence before a court of law. Victim was raped on gunpoint, and the same gun was also used to fire a shot at the witnesses while they were approaching the place where crime was being committed. Honorable Court, the Council requests your attention on para 61 of our submissions, where confession of Rakesh Kumar disclosed the possible headout of the other three accused. Moreover, their apprehension caused discovery of the pistol used by the accused persons to flee from the incident. Consequently, Desi Katta country-made pistol recovered from the accused persons after a case confession corroborates under Section 27 of Indian Evidence Act. Therefore, shall be deemed to be admissible by this court. Arrest of accused 2, 3, and 4 and search of place was done in front of independent punch witnesses, namely Hemant Kumar and Kundan Kumar, who have also signed the arrest memo of the accused person 2, 3, and 4. as the capacity of independent witnesses, so assumption of falsely implicated in the case is ruled out. It is well settled law that whether the weapon of offense was deadly or not is a question of fact which would depend on the nature of the weapon used in the offense. However, in general, a pistol, revolver, sword, axe, or even a knife are considered deadly weapons. Honorable Court, the victim in the present case is a submissive victim, while her soul was hostage due to the physical and sexual abuse by 4 persons. Her life was hostage on the gunpoint. Your Honor, further, if you would refer to the ballistic report on page 37, the capacity of shot being fired from the gun recovered has been authenticated. The shell which came out of the shot fired on the witnesses was also examined by the CFSL, along with the fingerprints of the accused Ajay Kumar and fingerprints on the gun. The evidence altogether surfaced to the guilt of the accused person. CFSL report shed light upon the normal working of the pistol exhibit 8mm .315 bore country-made pistol marked F1 in the laboratory. F1 is the country-made pistol and TB1 to TB3 are the sample bullets. Ballistic report shows that the empty cartridge EC1 recovered was compared with the cartridges recovered during arrest TC1 to TC5. Furthermore, the physical and microscopic examination of exhibits marked EC1 shows that it's an empty cartridge. After thorough examination and comparison, firing pin and breech face marks present on exhibit cartridge case marked EC1 were found similar with the firing pin, and breech face marks present on cartridge cases marked TC1 to TC5, which are the cartridges recovered from the possession of the accused persons. Hence, it is opined that the exhibit 8mm empty cartridge case marked EC1 has been fired through the exhibit 8mm .315 bore country-made pistol marked F1. Your Honor, summarizing my arguments, counsel firmly postulates that the evidence on record brought by the prosecution is sufficient enough to cast aspersion on activities of the accused and shake the conscience of any prudent person. Thus, exercising powers under Section 228 of the CRPC, Session Court can proceed with the trial after framing charges. Your Honor, no counsel would seek permission of Honorable Court to proceed with the prayer clause.
Before that, there's a question with respect to the recovery of the empty cartridges. So probably no empty cartridges because the evidence shows that what has been stated is that the one of the accused, he had fired at the place where she was found, the vacant plot. But then no empty cartridges were recovered from that vacant plot. Then how do you then, what about this discrepancy then? How do you explain this with respect to as far as the Arms Act is concerned, the charge sheet under that?
No, Your Honor, there was a very beautiful coordination between all these persons, if we see. And also when the disclosure statements were made by the Rakesh Kumar in the police custody, who was arrested before, then only another 3 persons were arrested from one residential house. And from their possession, this desi kata was also recovered. And Your Honor, this was the same desi kata which was used by these people to retaliate when the neighbors proceeded towards the plot.
All right, no,
also,
yes.
The CFSL report confirms the fingerprints of one of the accused, Ajay Kumar, also on that same pistol.
From where were these empty cartridges recovered by the police? Which were fired according to the statements? Yes. According to the FIR?
Only one shot was fired there.
Yes.
At the place of incident. And then pistol fell from the hand of one of the accused. So that empty cartridge was recovered from that particular place.
All right. Okay, you may proceed.
Just one question.
Yes.
What will be the consequences of non-examination of the accused medical examination?
So it is, although under provisions of the CRPC, it is mandatory to get the accused examined. But in this case, the accused was not examined, and according to the facts as were provided to us, there is no mention as to whether accused was examined or not. So I think it will not have a material effect when we have another eyewitnesses present and whose evidence is of sterling quality, and when we cannot attribute any ulterior motive on any individual that they are trying to
No, because
implicate
in
them
in
for.
a case where you're saying there was there's no history of any background between the victim and the accused persons. The identification is only with respect to the fact that she knew that they were residing locally there. Third, the timing of the case, it's 8:30 in the morning. In a
Yes,
busy
Your
locality and a busy crowded place like Uttam Nagar, Mohan Garden, which is densely populated, and the topography of the area also would reveal that it is not a place where there could be any vacant place, and that too in the morning for a very long time. Third, the fact that even in the MLC, there's a clear-cut finding, even though no history of physical assault. Hymen torn is something which, again, if you go to the scientific evidence, hymen can be torn on various other reasons. There is no previous, as we said, there is no previous background to the victim and the accused. So in these circumstances, non-examination of the accused person as per their requirement, what would be the consequences?
No, sir, I don't think it will have any material consequences, because the medical report by Dr. Hemlata, it confirms that there are abrasions on both the breast of the victim. So this shows that the minor tried to struggle and offer resistance when
I
assault was
also couldn't
committed.
find anything on FSL of the clothes of the victim. Is there any report on record?
No, Your Honor.
What are the facts? What are the statement of facts, sir?
No, Your Honor, we don't have clothes or anything like that, but the eyewitnesses, they say this thing that
No, but
she was
the
wet.
MLC says that samples have been taken. What samples were taken?
Yes, Your Honor, those samples were taken, but yet we have not got that report. Maybe during the further proceedings, that a report will be submitted by the
So
prosecution in the honorable.
your primary, this thing is at the stage of charge. And for charge, the material today is sufficient, right? The witness of the statement of the victim and the so-called eyewitnesses who were at the spot when they saw them running away. So these two itself would be sufficient to go ahead and frame the charge. Or under what charges?
Honorable Court, if the speaker one may have the permission of the court to answer their questions.
Please.
Please, Your Honor. Honorable Court, the fact that offence was committed in the broad light in Uttam Nagar, which has the veracity that has been densely populated. However, it was committed in the morning of February at around 8 a.m. The victim was kidnapped en route to school, which can be implied that people might have not awakened by that time. However, the other fact which can be corroborated with the kidnapping is that the victim was found and further taken to the vacant plot. However, she was en route to her school. Honorable Court, further, the evidence on record, that is the hymen torn, is the consequence that she was also found bleeding from her private parts when the offense was committed, which consequently
That
can be
observation
construed.
is not there in the MLC. It's only the history given by the victim. That observation is not there.
Honorable Court, MLIR, if the counsel may have the permission to speak, MLIR do not construe, cannot be construed as the final submission of the medical evidence. MLC will be provided with this Honorable Court when the FSL report.
What will be the conclusive medical listing if MLC is not there?
Please, Honorable Court. Honorable Court, MLC, final MLC, along with the samples which has been sent to the FSL, will be concluded as the final evidence of medical record. However, for the primary stage, when the charges are being framed, MLIR can be construed as the fact that she was medically examined as per the procedure established by the law, and there has been hymen torn, abrasions on her breasts particularly, which can be concluded as.
The question was different. The question was different in the context of these things. The procedural requirement of examination of the accused persons. That is something which.
Please, Honorable Court. Honorable Court, in the present case, however, the prosecution submits to the fact that medical examination of accused hasn't been done so far. However, the DNA sampling and further samples can be taken further once the samples of the victim may come to the prosecution. The report can further be.
Now, what provision will do that?
Honorable Court, Section 53A, which states about the medical
No.
examination of
Post filing of the charge sheet, you have to take medical, you have to take samples again with the accused person. Now, what provision of law would you seek that under? Investigation is complete, charge sheet has been filed, they're facing trial. So even if the charges are framed acquit them and they are facing prosecution, and then subsequently you feel the need of taking their samples, under what provision of law would you do that? You have the powers.
Honorable Court, the council can do the medical examination for the, I believe, under, if the Honorable Court may allow the council to peruse to the facts.
All right,
of the case.
proceed. Fine, it's all right. Please proceed with your submission. Thank you.
Much obliged, Honorable Court.
Honor, the council now seeks permission of the Honorable Court to proceed with the prayer clause. In light of the issues raised, arguments advanced, and authorities cited, the Council of the State humbly prays that the Honorable Court be pleased to adjudge, hold, and declare charges sustainable under IPC 1860, Section 361, 363, 376DA, read with 120B and 34, POCSO Act Section 6 and Section 8, Juvenile Justice Act 2000, Section 15 and 18, Arms Act 1959, Section 25 and 27, and pass any other order, direction, or relief that it may seem fit in the best interest of justice, fairness, equity, and good conscience.
Thank you.
Yes, please.
Your Lordships, I seek permission to address the bench collectively as your Lordships.
Yes.
Much obliged, your Lordships. Greetings to the bench. The counsel for the accused in this matter shall be addressing the first and third issue that has been brought up before the Honorable Sessions Court. My co-counsel would address the second issue at hand. I would be taking 20 minutes of this Honorable Court's time, and my co-counsel will be taking 23 minutes of this Court's time, reserving 2 minutes for rebuttal and rebuttal as the case may be. Your Lordships, I request the use of screen sharing to highlight important factors of the matter at hand.
Yes.
Much obliged, your Lordships.
Requesting the court master to give me the permission to screen share.
Yeah, I'm doing that.
Your Lordships, with the permission of the bench, the counsel for the accused would humbly submit the pleadings.
Yes, please.
Much obliged, your Lordship. Your Lordships, I shall be addressing the first and third issue at hand, that is, whether charges can be framed against the accused for offences of kidnapping as stated in Section 361 and 363 of the Indian Penal Code, and conspiracy as defined in Section 120A in committing the alleged crimes. Secondly, whether charges can be framed against the accused for use and possession of an unlicensed arm as defined in Section 25 and 27 of the Arms Act. The counsel humbly submits before the Honorable Sessions Court that charges cannot be framed against the accused under Section 361 and 363 by way of threefold argument. Firstly, there exists sufficient grounds for discharging the accused under Section 227 of the CRPC. Secondly, the only thing linking the accused to the charge of kidnapping is the contents of the FIR and the charge sheet and the accused's confession in police custody, which are not substantive pieces of evidence. Thirdly, there exists no criminal conspiracy between the four accused to commit the alleged crimes. Your Lordship, Section 227 of the CRPC grants power to a sessions judge to discharge the accused upon analysis of the documents submitted before this court and upon hearing the contentions of the two parties. This power has been described by the Delhi High Court in the case of Deepak Dua versus State and another. In this case, it was held that if two views are equally possible and the judge is satisfied that the evidence produced before him while giving rise to some suspicion but not grave suspicion against the accused, he
Tell
will
me,
be.
counsel, why should we not disbelieve the witnesses at this stage? Simple question.
Could you rephrase that question?
Why should we not believe the witnesses, the statement of witnesses at this stage?
Your lordships, you should not believe the witnesses at this stage due to certain contradictions in their statements and the lack of evidences provided in this present matter. I will
No,
describe.
that is something which should be subsequently, adjudicated upon when they come in the witness box. So contradiction can be put to those witnesses. But at this stage,
Indeed.
why should we start a roving inquiry and see whether contradictions are material enough for you to get discharged? Today, there are two witnesses, in fact, two set of witnesses. One is, of course, the victim, whose testimony would be most relevant. And of course, there is a chance eyewitnesses on the spot
Indeed, your
who
lordship.
see you at the spot. Why should we disbelieve those witnesses and discharge you? A simple question. And at this stage.
Yes, indeed, your lordships. Much obliged. Your lordships, I would like to cite the case of State of Orissa versus Devendra Nath Pati, where it was held that Section 227 was incorporated with the view to save the accused from prolonged harassment, which is a necessary concomitant of a protracted criminal trial. When the evidence.
What was the issue in Padi?
Your lordships, in this case, your lordships, I have cited this judgment to primarily rely upon the power of the court to discharge.
Yeah, but the power of court 227 was in a different context. It was respect to some documents which could have been placed at that particular point of time. Material on behalf of the defense. Do you have any material on behalf of defense to show that these witnesses are not reliable? Any previous enmity between you? Any previous relationship between you and the victim? Anything
your
to show that?
In your lordships, I am primarily relying upon the bullet not being found at the crime scene in the Arms Act offense. Your lordship, that is a very necessary aspect of the evidence which the prosecution has failed to provide.
You will be acquitted of Arms Act.
Indeed.
If that is the case, if that is the only ground that you are taking, not finding of a bullet. But what about the statement of victim? Why has she identified you? Why has she named you? Is there a previous enmity? Is there something which there is a previous background because of which she would probably, falsely implicate you? Anything on record?
No, your lordship, there is no record of personal enmity according to the facts of the case. But your lordships, I humbly submit that in charges of kidnapping, the burden of proof exists on the prosecution to prove that the offense actually happened, and in there's a reverse burden of proof in rape charges, which my
No, we're talking about the stage of charge. Obviously, towards the end of the trial, the burden is on the prosecution to never shift. But at the stage of charge, what else should they bring on record?
Your lordships, I have relied upon the fact that no eyewitnesses of the alleged kidnapping were present. Your lordships, the prosecution has described how they were last seen together at the spot, but no eyewitnesses actually exist to show that the four accused actually took the victim from her while she was traveling from school. There is no evidence provided on the record with regards to this. Your lordships, I would like to cite the case of Chandrapal versus State of Maharashtra here, where it was held by the Honorable Supreme Court that when evidence is circumstantial in nature, no conviction can be made on the basis that the accused were last seen together, even though this may be proven.
What was the stage in that case? Was it a case of discharge or acquittal?
Your lordships, that was an acquittal. That was a case of acquittal, but I have cited this case to prove that last seen together is not a ground for proceeding for convicting the accused and proceeding.
Any judgment that you can cite on charge, the stage of charge?
Your lordships, I would like to reiterate the Prafulla Kumar Sanal judgment here, where it was held that the evidence produced before the sessions judge, while giving rise to some suspicion but not grave suspicion. Your lordships, I submit that grave suspicion does not arise against the accused in this present matter, and my co-counsel would further elaborate upon this matter, but I would, at this preliminary stage, I would like to cite that how the offences of kidnapping and arms act.
All right, proceed. Thank you.
Much obliged, Your Lordships. Your Lordships, I would, since I have addressed the primary charges regarding kidnapping and how there exists no eyewitness, I would like to proceed as to an important aspect of which the prosecution has ignored. Your Lordships, no tangible explanation has been provided as to why the confession was not made before the magistrate when they were arrested. There's an important requirement of Indian criminal procedure law laid down in section 164, and not following this is, in the council's humble opinion, an ignorance of law. Your Lordships, the Guwahati High Court has held in this case of State of Assam versus Ramindranath Guha that when the accused has not been explained the nature of confession to a magistrate, such a confession cannot be accepted as a part of evidence. Your Lordships, the confession, I humbly submit that the confession is an important piece of evidence here, due to the fact that through the confession, the police has obtained facts as to how the accused allegedly committed the crimes. Their bikes were recovered from the spot. Later, the guns were also recovered. Your Lordship, since this confession is itself put into doubt, I humbly submit that charges cannot be framed due to the non-reliability of this confession. Your Lordships, if the court is pleased with the first limb of argument, I seek permission to proceed to the second limb of the argument.
No, but what about section 27 of the Evidence Act?
Your Lordship, section 27 of the Evidence Act allows discovery of a new fact when if the statement is made in police custody. But I would like to humbly submit the case of Muhammad Inayatullah versus State of State of Maharashtra here, apologies. This was held that there must exist a proximate cause between the discovery of the fact and the commission of an offense. In this case, this was an essential requirement of the law, and we humbly submit that this requirement is not fulfilled here.
Why is it not fulfilled here?
Your Lordships, because the alleged recovery of the gun, and the claim of the witnesses that a bullet was fired are unsubstantiated due to the fact that no recovery of the bullet was made at the crime scene.
No, that's subsequent. The allegation with respect to the gun being used for the crime, both during the course of the crime and post-crime, and the recovery. Why do you say that is not connected?
Your Lordships, I submit that because
whether that's the same pistol or not, that's again a matter of trial. But at this stage, again, we are asking at this stage, why is it not connected?
Your Lordships,
and the bikes also, because the bikes also been mentioned.
Yes, Your Lordships. Your Lordships, I humbly submit that even if I reiterate the observations of Praful Kumar Sanyal, even if suspicious circumstances exist, there must be the term used by the Honorable Court there is grave suspicion. Your Lordships, grave suspicion formation is an important requirement to determine charges, and I humbly submit that grave suspicion cannot be formed on recovery of gun if it is not proven that the gun was fired for an anti-social purpose, which is an important requirement of the Arms Act, Your Lordships.
The Arms Act.
Yes, Your Lordships. 20 Gunwant Lal versus State of MP has described that the intention and knowledge of use of the gun is also a very important requirement.
Proceed.
Much obliged, Your Lordships. Your Lordships, I would like to cite my arguments as to how criminal conspiracy has not been formed in this present matter. Your Lordship, section 120A of the Indian Penal Code defines criminal conspiracy. It is defined as following: when two or more persons agree to do an illegal act or an act which is not illegal by legal means, such an agreement is designated as criminal conspiracy. In the case of Parveen versus State of Haryana, the Honorable Supreme Court has stated that without having any direct evidence of meeting of minds of the accused, it cannot be proven that there is a criminal conspiracy. In the case of NCT of Delhi versus Shiv Charan Bansal, the Honorable Supreme Court held that the acts or conduct of the parties must be conscious and clear enough to infer their concurrence as to the common design and its execution. The Lordships, in the Shiv Charan Bansal case, one of the accused was discharged by the court due to lack of evidence of his involvement in the crime. Your Lordships, neither of the accused had any association or relation to lead the conspiracy. It has not been established by the prosecution that any prior meeting of minds of the accused took place and the formation of an agreement was existed to commit the alleged crime. Your Lordships, according to the Honorable Supreme Court, in the case of Sanjeev Kumar versus State of Himachal Pradesh, proof of formation of agreement is extremely essential to convict an individual of this charge. Your Lordships, I therefore humbly submit that no charges of criminal conspiracy can be formed against the accused due to lack of proof of prior consent. Your Lordships, I seek permission to proceed to my arguments with reference to common intention with regards to Arms Act offence.
Please.
Much obliged, Your Lordships. Your Lordships, according to the Honorable Supreme Court in Virendra Singh versus State of MP, common intention is always developed prior to the crime taking place. And while there need not be a large gap between the development of a common intention and the crime taking place, the intention must arise before the crime taking place. Your Lordships, I humbly submit that that in the given circumstances there was no predetermined intention for the two accused, Anil and Anuj, to use the weapon in any way to commit the alleged offences. Your Lordships, I also submit that the essential ingredients of Section 25 of the Arms Act are also not met to convict Anil and Anuj Kumar. I cited the Gunwant Lal case earlier to describe how the use of the use of guns for an antisocial purpose is also very important. But Your Lordships, another essential ingredient which I will cite now is the fact that constructive possession of the gun through which an individual has power and control over the gun is also necessary. Your Lordships, I humbly submit that on application of this precedent, it is observed that these ingredients are not fulfilled in the cases of Anuj and Anil Kumar. Both of them had no intention of using the firearm to commit the alleged offense, and they had no possession of any kind or control over the gun. No physical possession or constructive possession existed. Your Lordships, I seek permission to proceed to my arguments for determining the guilt, for determining whether charges can be framed against other two accused or not.
Yes.
Much obliged, Your Ladyship. Your Lordships, I humbly submit that the claim of the accused, the claim of the witnesses here that the gun was fired by the accused persons is unjustified. As I have cited in previously during the course of my arguments, I urge you to refer to page 10 of the charge sheet where Miss Kajal made the complaint that the accused fired the shot in the air to help their escape. Your Lordships, another witness provided by the prosecution, Mr. Satyajit, also mentioned this in page 22 of the charge sheet. Your Lordships, I humbly submit that due to no non-recovery of the alleged fired bullet at the crime scene, the prosecution relied upon exhibit cartridges as a reference in the ballistic report mentioned on page 38. Your Lordships, I humbly submit that this claim is not proven by the prosecution to the preliminary stage due to no discovery of a fact taking place and no proximate cause between the recovery of the gun and the use of the gun. Your Lordships, I have already described the Inayatullah judgment during my interactions with this honorable court, and I reiterate this that proximate cause must exist between the discovery of a fact or a document and the commission of the alleged offense. Your Lordships, I humbly submit before this honorable court that the remaining two accused are also not guilty under sections 25 and 27 of the Arms Act due to the fact that the intention of the use of weapons has not been proven to be against the law, which is a necessary aspect of the law. Your Lordships, I humbly submit that charges cannot be framed against the accused for the offences due under the Arms Act due to absence of common intention and lack of proof regarding the intention of ownership of the gun. Your Lordships, if you are pleased with my arguments, I seek permission to invite my co-counsel to address the second issue before this honorable court today.
Yes. You may proceed.
Much obliged, sir. Your Ladyship.
Good morning to the bench. The co-counsel for the accused shall be addressing the second issue that has been brought up before this honorable court. With the permission of the bench, the co-counsel for the accused would like to humbly submit its pleadings. I shall address the second issue at hand, that is, the accused has not committed rape of prosecutrix. If your lordships have no prior queries, the co-counsel would like to begin with its arguments.
Yes, please.
Much obliged, your lordship. The co-counsel shall humbly submit before this honorable court by a way of threefold arguments. Firstly, I shall appraise this court that there were not enough evidences to prove that the accused were guilty of committing rape of the prosecutrix. Secondly, I will explain that the statements made by the accused in the police custody were not admissible as evidence in the court of law as per Section 25 and Section 26 of the Indian Evidence Act. Thirdly, there were material differences in the statement of prosecutrix given under Section 161 and Section 164 of CRPC. Your Lordship, I will now establish before this honorable court that there was no medical examination conducted of the rape accused. Your Lordship, the medical examination of the accused is equally important as the medical examination of the victim. The need for the same has been provided by law in the CRPC via the 2005 amendment in section 53A subclause 1, which is examination of the person accused of rape by a medical practitioner. It mandates the examination of the accused by a doctor at a government hospital acting under the guidance of a police officer not less than the rank of sub-inspector to make such examination of the arrested person. And Your Lordship, in our case, there was no medical examination of any of the 4 accused, which is a clear violation of the procedural law on the part of the state. Here, Your Lordship, I would like you to refer to page number 12 of the Moot proposition. Your Lordship, are we on the same page?
Yes, please.
Your Lordship, in the fact sheet, it has been clearly evident that the accused were arrested by the police and then they were sent from police custody to judicial custody, except the juvenile who was sent to rehabilitation center. And there was no medical examination conducted of the rape accused. Moreover, Your Lordship, in the case of Krishna Kumar Malik versus State of Haryana, the Supreme Court observed that now, after the incorporation of Section 53A in the CRPC, it has become necessary for the prosecution to go in for the DNA test to prove that there was sexual penetration by the accused. In the provided situation, the accused didn't go through medical examination. There were no DNA collected, no semen collected, or any other forensic evidences collected. The accused have been charged of rape only on the statements of witnesses and prosecutrix. In the medical examination of the prosecutrix itself, it has only mentioned that there was rape, but proving that it has been done by the accused, the DNA of the accused need to be matched, but herein the DNAs of the accused have not been collected and thus it didn't been checked. So due to the lack of evidences and absence of medical examination of the accused, there has been no proof of sexual penetration on the part of accused. It cannot be concluded that they had committed rape or gang rape, and there is no strong evidences to make the accused guilty under Section 376D(a) of Indian Penal Code, Section 6 and Section 8 of the Protection of Children from Sexual Offences Act. If the court is pleased with the co-counsel's first limb of the argument that there was no medical examination conducted of the rape accused, the co-counsel would seek the permission to move on to the next limb of the argument.
There is one query by the court. One is, though no medical evidence of the accused may have been done, but the fact remains their presence at the site in question has been corroborated by all the witnesses, number one. And secondly, they have also verified, the witnesses, that the victim was bleeding from her private parts at that moment. So how do you explain the presence of these persons, the accused there, number one, and how do you, and because the circumstantial evidence clearly points out to their guilt. So obviously it is a matter of trial. With respect to whether or not they are guilty or not. But prima facie, at the time of framing of the charge sheet, the court would also see the circumstantial evidence with respect to their presence being there, the witnesses, all the witnesses corroborating that yes, they were present there, because it is not a case that their presence has not been established. And then the fact that the victim, she was found to be bleeding from her private parts, whereafter she was taken for the medical examination. So what do you have to say about this aspect?
Indeed, Your Lordship. Your Lordship, I would like to say that mere presence of the accused on the crime spot doesn't mean that they have committed the crime. It might be possible, it can be possible that they, all the eyewitnesses, prosecutrix, and the accused live in the same locality. So it is possible that they can be present at the crime scene. And with regard to the witnesses' statement, they are not that much reliable. Obviously, they have a very significant value in the court of law, but as of now, if there are no sufficient evidences to prove that the accused were guilty of rape, the witnesses' statements cannot be that much reliable. and the prosecutrix was bleeding from the private part, her hymen was torn, proves that she was being raped. But as such, there are no medical evidences to prove that she has been raped by the 4 accused. We cannot say that a benefit of doubt must be given to the 4 accused.
Yes, but the victim has been very consistent in her statement with respect to all the 4 accused.
Your Lordship, I would like to say that there are material flaws in the statements of the prosecutrix, which she gave in the presence of police officer, and one she gave under the presence of metropolitan magistrate. There were significant changes in the statements. In the first statement given under section 161, she said that all the 4 accused kidnapped her on the gunpoint, and then they took me on 2 motorbikes to a vacant plot. And in the next statement under 164, she said that she mentioned specifically Rakesh, who took her to the vacant street, and then the 3 of them also accompanied him and then took her to a vacant plot. So there are material differences in the statement. So the prosecutor's statements in the present case cannot be that much reliable to convict the 4 accused.
All right, but then these cannot be considered as material discrepancies as such. There may be minor discrepancies, but then it cannot be considered to be a material discrepancy as to discard her testimony altogether.
Indeed, Your Lordship, but the council states that if the prosecutrix is not reliable, a benefit of doubt must be given to the accused, and the prosecutrix should be sent for cross-examination, because there are flaws in her statement, and the materials have been the statements have been different. And herein I would like to cite the case of Mathur versus State of UP, in which the UP High Court set aside the order of the trial court, wherein because the trial court convicted the accused on the basis of the statement of the prosecutrix, but later on it was found that the statement of this prosecutrix was changing the statements frequently, and there was flaws in the statement. So UP High Court set aside the order of the trial court and acquitted the accused, merely because on the alteration of the statements on the part of prosecutrix.
All right, you may proceed with the next point.
Much obliged. Your Lordship, now the co-counsel will explain the Honorable Court that there has been violation of Section 25 and Section 26 on the part of police officers in the present case. Your Lordship, there has been a series of violations on the part of state. First, there was procedural violation in aspects of medical examination, and now I shall bring it in front of the court of law how the state is violating and using the laws made to secure the innocent to instead convict them of offences not committed by them. Your Lordship, it is most humbly responded before this honorable court that the statements made by the accused in the police custody are not admissible in the court of law, according to Section 25 and Section 26 of the Indian Evidence Act, which states that no confession made to a police officer shall be proved as against a person accused of any offences. This principle has been reiterated in the case of Agnu Nagesia versus State of Bihar. The court used the word imperative to describe this provision. It explicitly lays down that the law, no matter the circumstances, a confession made to a police officer is not admissible. Furthermore, Your Lordships, the police have not followed the principles of recording a confession under Section 164 of the CRPC. The accused were not brought before the magistrate to record their confession, which is a violative of Section 281 of CRPC, which is in contravention of the existing Supreme Court guidelines. Therefore, Your Lordships, in the present situation, the statements made by all the 4 accused are not admissible in the court of law as it is given in police custody. If it does so, it would be a violative of Section 25 and Section 26 of the Indian Evidence Act. Hence, the statements would only be admissible if it is given in the immediate presence of the metropolitan, in presence of any judicial magistrate. If the court is pleased with the co-counsel's second limb of the argument that the statements made by the accused in the police custody are not admissible in the court of law, the co-counsel would seek permission to move on to the next limb.
Yes. Correct that it is inadmissible as per Section 25, but What about 27? This is the disclosure and the recovery. And also, if can the police officer, the investigating officer, take a accused to the magistrate straight away and get his confessional statement recorded? Is that the procedure?
Yes, Your Lordship. After the rape has been committed, it is the duty of the police to take the victim as well as accused to the for recording their statements in the presence of a judicial magistrate.
Where do you get that?
Your Lordship, it is mentioned under section 164.
What does it say, 164?
Your Lordship, according to section 164, which states the recording of confession and statements, and subclause 1 says that any metropolitan magistrate or judicial magistrate may, whether or not has the jurisdiction in the case, record any confession or statement made to him in the course of an investigation under this chapter or any other law for the time being in force or any other time afterwards before the commencement of the inquiry or trial.
Now, please read further.
Your Lordship, can you again repeat? I was unable to hear that.
So please read further.
Yes, Your Lordship. Your Lordship, subclause 2 of the section 164 states that the magistrate shall, before recording any such confession, explain to the person making it that he is not bound to make a confession, and that if he does so, it may be used as evidence against him. The magistrate shall not record any confession unless, upon questioning the person making it, he has the reason to believe that it is being made voluntarily.
So, unless the accused person desires that he wants to make a confessional statement, no police officer can take him there.
Yes, Your Lordship.
So then why is this proposition being submitted that the police ought to have taken these people to confessional statement? You see, statement on 24 is a statement before a police officer. It's during the course of investigation, they make a statement, and subsequent to that, a recovery may be effected. But your proposition that the police ought to have taken them to magistrate for 164, I don't know where you get this from.
Your Lordship, the police officers, after recording the statement, have the duty to produce the accused in front of the magistrate under section 164, and they fail.
Where do you get that? Where is that compulsory? They have to produce the accused before the magistrate within 24 hours to get a further remand. That's all. 164 is only if the accused person wants to give a confessional statement. He's produced before a magistrate who is further then, he refers it to some other magistrate, and then the confessional statement is recorded. It is not the police. There is no procedure where they have to compulsorily be produced before a magistrate to get the statement recorded.
Your Lordship, but there's a provision that says that within the 24 hours, the police has to produce the accused in front of the magistrate.
Which section says that? It is not 164, it's 167. And that is only for further remand. That's all. It is not for recording a confessional statement.
Your Lordship, the co-counsel seeks permission to interject here.
Yes.
Your Lordships, while there is the Q164 confession is voluntary, Your Lordships, in the present matter at hand, the accused's confession is a very important piece of evidence being provided by the prosecution. Your Lordships, as my co-counsel has already previously mentioned,
I don't think so. This argument is not there. The most relevant piece of evidence that Justice Pushkarna also pointed out was the statement of the victims and the other the so-called chance witnesses who happened to come on the spot. Confessional statement is not important.
Indeed, Your Lordships, I agree that the statements of the victim is important, Your Lordships, but I humbly submit that, as I have already previously stated in my
No, but just to point out to you that the proposition that you're saying is incorrect. So just keep that in mind. That's all. Please proceed.
Indeed, Your Lordships. Your Lordships, I am stating the fact that why stated this in my arguments. Mere suspicion of the against the accused is not sufficient to begin trial, and if grave suspicion does not exist, the discharge may take place. Your Lordships, the medical evidence not being examination of the accused not taking place. Your Lordships, even the nature in which the confession was obtained. Your Lordships, I submit that the statements are a doubtful piece of evidence and do not lead to a case of grave suspicion.
All right,
That is
please
the
proceed
submission.
with your submission. Thank you.
Your Lordship, it is now the co-counsel seeks the permission to move on to the next limb of the argument.
Yes, please.
Your Lordship, it is most humbly submitted before this honorable court that there are material differences in the statements made by the prosecutrix under section 161 and under section 164 of CRPC. Here, Your Lordship, I would like you to refer to page number 17 and 18, which is statement given to the police officers, and page number 33 and 34, which is statement given in the presence of Metropolitan Magistrate of the Moot proposition. Are Your Lordships on the same page with me?
Yes.
Your Lordship, there are differences in the statements made in front of the police officer and one made in front of the Metropolitan Magistrate. In the first statement given under section 161, she mentioned that all four accused kidnapped her on the gunpoint with two motorbikes and took her to a vacant plot in a locality. But in the statement she gave under section 164, she mentioned specifically Rakesh, who took her to a vacant street, and thereafter three accused joined him later. Therefore, I urge the court to disregard these conflicting statements of the victim in the present case. To support this contention of mine, Your Lordship, I would like to cite the case of Mathur versus State of UP, in which the UP High Court set aside the order of the trial court, which convicted the accused under the rape charges due to the material and significant alteration in the statements of prosecutrix. Moreover, Your Lordships, it is noticeable that the medical record and the doctor's evidence do not specify whether there were any signs of possible sexual intercourse, and keeping in view these changes in the statements, it has been inferred that the statements of prosecutrix is not reliable and shall be considered a statement in lieu of examination in chief, as specified in section 137 of the Indian Evidence Act, such that the maker of the statement can be cross-examined as on such statement without the need for recording the same at the time of trial, provided under sections 164, 5, subclause 5A, subclause B, and then it should be left to the wisdom of the court to do justice. Your Lordship, in the case of Atindra Yadav versus State of Government of Delhi, wherein the court held that we are not here suggesting that in every case the testimony of child witness should be looked upon with suspicion, but before the same is believed as a reliable and truthful statement, due care and caution should be taken looking into all the facts and circumstances of the case. Your Lordship, I would like to cite one more case. In the case of State versus Sohan Lal, the court observed that there is no dispute that the conviction can be based upon the sole testimony of a child witness in the cases of sexual assault, but the necessary precondition thereof is that the evidence of the child victim should not be a result of tutoring. In this case, circumstances clearly point out that the evidence of child victim is not free from the blemish, and as such, it would be highly unsafe to convict the accused merely on the basis of her evidence. Hence, Your Lordship, it has been made clear that the victim's statements also needs to be checked if it is correct. Then only the accused should be convicted. Your Lordship, since the state has produced non-admissible statements in the court coupled with breaking of procedural laws by not conducting medical examination of the four accused, and the statements of prosecutrix being conflicting, led to a failure on the part of state to prove that the four accused, Rakesh Kumar, Anuj Kumar, Anil Kumar, and Ajay Kumar, are not liable under section 376DA of Indian Penal Code, section 6 and section 8 of the Protection of Children from Sexual Offences Act 2012. If the court is pleased with the co-counsel's arguments, the co-counsel would seek the permission to recite the prayer.
There's a query by the court. The discrepancy which you have pointed out with respect to statements under section 161 and 164 these statements can have a bearing on the issue of probably the charge of kidnapping. But as far as the charge with respect to rape is concerned, this discrepancy in the statement will not have bearing on that. That's number one. And secondly, what is the basis of your statement that the witness is tutored? Because as such, except that the little discrepancy which you have pointed out in the statements under 161 and 164, so merely on that ground, how can there be a presumption that the witness as such, the victim as such, is a tutor witness? Because this is merely a presumption on your part then.
Your Honor, witness is not tutor. We are just referring to the Soham Lal case that in every statements made by the child victim, we cannot consider it blindly, even though it is obviously specified that sole testimony of the victim is enough to convict the accused. But herein, we need to also focus upon and also cross-examine and check out whether the statement is true or not. And in this case, in the present case, obviously, the prosecutrix is not tutor, but there are differences in a statement, and kidnapping and rape, both offenses are linked together. So she is making false allegations on the part of accused that they have kidnapped me and later raped me. And in the first instances itself, she has stated false, changed evidences, changed statements, whether how the kidnapping was done. So these two offenses are interlinked. So we cannot say that she was talking about kidnapping. She was not talking about rape. So that's why these both offenses are linked, and there has been material significant changes on the part of the prosecutrix.
All right, you may proceed to the next point.
Much obliged, Your Lordship. Wherefore, in the light of the issues raised, arguments advanced, and authorities cited, it is humbly submitted that the Honorable Court may be pleased to, first, not to charge the four accused for the offences of gang rape and sexual assault of Manisha under Section 376D(a) of IPC and Section 6 and Section 8 of the POCSO, that they have been charged for the same by the state. Second, not to charge the four accused for the offences of kidnapping and criminal conspiracy under Section 361, 363, and 120B, read with Section 34, and committing the alleged crimes. Third, not to charge the four accused for the offences of sale or illegal use of arms and ammunition as under Section 25 and Section 27 in the Arms Act 1959, and pass any order, direction, or relief that this Honorable Court may deem fit in the interest of justice, equity, and good conscience. It was a pleasure pleading before this court.
Honorable Court, does the prosecution counsel have the permission of the court to proceed with the rebuttals?
Yes.
Much obliged. Honorable Court, the counsel would begin the rebuttals with reminding defense counsel that the case is at the stage of arguments on charge, for which the prosecution need not necessarily prove the charges beyond reasonable doubt. Moreover, Honorable Court, the counsel would also state that the judgment holds what flows from it and not what is inferred from it. Most of the judgments or citations that has been cited by the defense counsel has different circumstances than in the present case. Honorable Court, further along, the counsel would also like the Honorable Bench to consider that defense is craftily circumvented through the statement under Section 164 and 161 of CRPC, where the prosecutrix, in fact, has been consistent throughout about the commission of rape. Further, statement under Section 161 of CRPC, even when do not create substantive evidence, it can be used for contradiction purposes, which the defense counsel has failed to appreciate. Besides, it is critical to note that the defense has in fact admitted the guilt of accused person Rakesh Kumar and Ajay Kumar regarding the possession of weapon, and then have failed to establish the grounds or defend the grounds under Section 25 and 27. They have admitted the possession of gun with the accused person Rakesh. Therefore, Desi Kata or the country-made pistol, which is alleged in the present case, is a prohibited arms under the Arms Act, and therefore they have failed to defend the accused persons on the same ground. Honorable Court, further, Rakesh Kumar and moreover regarding the minor contradictions as to who took her to the vacant plot does not discredit the case of prosecution. In fact, the reason of the shift in statement is because the prosecutrix was traumatized. Even when the prosecution witnesses 2, 3, 4, and 5 came to her after the accused person fled from the scene, she was unable to answer any of their questions. In medical science, it is referred as shock disbelief, which is part of acute phase of rape trauma syndrome. After her statement under Section 161 of CRPC and medical examination, she was counseled by the NGO ACHA, after which her statement under Section 164 has been recorded. Honorable Court, the deposition of the victim in the present case is reliable, trustworthy, and there's no reason to discredit or reject the same merely on the basis of minor contradiction that accused persons were not medically examined or semen test has not been conducted, considering that the accused were arrested after 15 days of the commission of the crime. Honorable Court, the defense not only has forgotten to discredit the charge under the JJ Act, they have failed to provide a reason as to why were accused persons found by the prosecution witness 2, 3, 4, and 5 with the victim on the plot where crime is alleged to have been committed if there are no circumstances as have been alleged by the defense counsel. In regard to the mental capacity of accused person Rakesh Kumar, Honorable Court, Rakesh Kumar vigorously firing the gunshot at prosecution witness is adequate to place his criminal mental capacity, ability to understand the consequences at the same stake as other accused persons. Ultimately, Honorable Court, the horrible act committed by the accused persons cannot be defended by the reason of minor contradiction. Not only does it add to the injury of the victim, it is not capable to discharge accused persons for the crime committed by them in regard to the evidence on record. Honorable Court, there's been manipulation of facts by the defense counsel as regard to the proposition submitted and the facts of the case that the fire was shot in the air. It was the gunshot fired by the accused persons were upon the prosecution witnesses who were approaching the same vacant plot in order to save the prosecutors. Honorable Court, they were not merely present at the crime scene, which the counsel for defense has admitted. They were seen by the prosecution witness 2 and 3, that is Kajal and her husband, physically and sexually abusing the minor child. Honorable Court, they have admitted the commission of rape. What cannot be overlooked is the fact that prosecutrix has made a sterling witness in regard to who committed rape upon her. Therefore, the plea that accused persons did not commit rape upon her, whereas rape has been committed, has no grounds in the present case. Honorable Court, that is it with the rebuttals. Prosecution. Court does not have any
Your Lordship,
questions.
I seek permission to.
No, there's one query.
Yes.
See, one is there are two facts that have emerged from whatever you stated. One is,
Please, Honorable.
as far as the commission of offense of rape is concerned, there is no independent eyewitness who has stated that they have seen the accused committing the offense. That's one. And then coupled with the fact that in this case, the accused have not been examined. So how do you explain that with respect to the framing of charge? And saying that they, yes, and saying that they are not, yes.
Honorable Court, in regard with medical examination of accused, further as the trial proceeds, they can be medically examined and the DNA samples can be taken as per Section 53 of CRPC. Although 53A hasn't been comprised with, and the prosecution counsel understands the consequences and apologizes for the same. However, that shall not discredit the sterling quality of statement made by the prosecutrix in the present case. Honorable Court, furthermore, even though there hasn't been any direct evidence of penetration, the hymen con was in consequence corroborates the statement of her bleeding from the private parts, which has been confirmed by the eyewitnesses and by the prosecutrix herself. Honorable Court, since the rape was being committed in dense bushes, it wasn't possible for the eyewitnesses, second and third, prosecution witness 2 and 3, Kajal and her husband, to see from the terrace as to if penetration was happening or not. However, the fact that hymen was found on and abrasions were found on the breasts of the victim specifically calls for the record that resistance has been made and the bleeding can further inferred as penetration, Honorable Court, by the accused persons. And not to be overlooked, Honorable Court, lastly, that the defense counsel not only have admitted under Arms Act the illegal possession of the country-made pistol, they have admitted the commission of rape and they've admitted to the presence of accused persons in the crime spot as per their arguments and their submissions.
All right.
Much obliged, Honorable Court.
Lordships, I seek permission to reply to my learned friend's contentions.
Yes.
Your Lordships, as my learned friend constantly stated, we have admitted to the possession of the weapon and the fact that the accused were at the crime scene. Your Lordships, I have both me and my co-counsel have stated in the fact that mere seeing together and seeing at the crime scene is not a ground for conviction. I reiterate the Chandrapal case here. And with regards to the claims of the Arms Act, your ladyship, section 25 and 27 of the Arms Act also requires the proof of intention and knowledge of use of the weapon. Your ladyships, the prosecution has failed to prove that the intention and use of the weapon was for an antisocial purpose. The recovery of the bullet and not non-recovery of the bullet at the crime scene is an extremely important point that goes against the prosecution's case here. And your lordships, mere unlicensed possession of a weapon is not substantial grounds for conviction under section 25 and 27. The use and the intention is very important to consider while determining conviction. Your lordships, with regards to my learned friend's claims that the prosecution, that the defense has admitted to the charges of rape as well. Your lordships, we are not denying here at all that sexual assault may have taken place against the victim. We are denying the fact that the four accused were involved in the commission of the crime. The medical evidence under 55A is an extremely essential important, your ladyships. The prosecution's claim that it may be done later while the trial is taking place. Your ladyship, I humbly submit that it is a violation of the accused's rights here. Your ladyships, I reiterate the case of Praful Kumar Sanal here, where it was stated that grave suspicion is essential to form charges. Your ladyship, grave suspicion is not being formed in the present case. While suspicious circumstances may exist, your ladyship, grave suspicion does not exist. The victim statements, while they cannot be disregarded, are not sufficient on their own to constitute grave suspicion. The lack of eyewitnesses of the kidnapping and the fact that medical examination of the accused was not conducted point towards the fact that grave suspicion cannot be formed in this case. Much obliged. Your ladyship, I just like to reiterate my learned friend's point, reply to my learned friend's point. Your ladyship, I agree that the framing of charges require less evidence, prima facie case to be made out. But as I have stated often in my arguments, the term grave suspicion is a term of interpretation, and I humbly submit that grave suspicion does not arise. Much obliged, your ladyship.
How do you explain the presence of all the accused at the site in question?
Indeed, your ladyship. Your ladyship, while the presence of the accused at the crime scene may seem suspicious, your ladyship, it is not a ground for conviction or framing of charges in the present matter. I have stated the Chandrapal versus State of Chhattisgarh case here, where it was held that last seen together is not a ground for conviction, even though this may be proven on record. That is my submission to this present matter.
All right.
Much obliged.
Honorable Court, I'm sorry, sir. Honorable Court, can the counsel please conclude in one line regarding Arms Act and the recovery of weapon, if the court permits?
Yes.
Honorable Court, the recovery of weapon after the confession made by the accused person in the custody of police under Section 25 can be corroborated under Section 27. Fingerprints of Ajay Kumar have been proved. Even the ballistic report and forensic science laboratory report, which shows in the present case, indicates the commission capability of the gun being fired by the same cartridges that was used at the crime when the crime was committed. And the 5 cartridges that has been recovered has also been found similar with the 1 shell cartridge that has been fired on the place of crime, Honorable Court. Therefore, corroborating with their guilt of usage of crime. Honorable Court, moreover, the recovery of gun has been made in the possession while the accused persons were arrested in front of independent witnesses, thus ruling out any false implantation by the investigation agency in the present case. That's all. Much obliged, Honorable Court.
Lordship, I seek just a minute's time to reply to that statement.
Yes.
Much
Yes.
obliged, Your Ladyship. Your Ladyship, my learned friend used the term, the indication of the fact that the gun was fired from the same bullet, and she referred to the use of empty cartridge here. Your Ladyship, the term, it has been stated by the prosecution in their charge sheet that the empty cartridge used is exhibit. It is nowhere mentioned in the facts that the exhibit cartridge was the one recovered from the crime scene. The empty cartridge has been used for reference, and it was the term used in page 37 ballistic report was similar, and a 98% match was found. Your Ladyship's the fact that similar gun may have the 8 mm bullet may have been fired does not indicate that actual firing took place, which is extremely important. Much obliged.
All right. Thank you.
Thank you.
Thank you.
Thank you, honorable judges and the team members for your participation. Now I would like to request the honorable judges to give their feedbacks to the teams. Justice Mini Pushkarna ma'am, if you may please.
I would say it was a good experience to hear all the speakers. By and large, I found that all of you have really worked hard and researched well on the propositions. And in fact, participation in moot court is like stepping stone to the real world of advocacy, actually, when you will be coming to the real courts and making your submissions before the court. And I would say that as a lawyer or as a moot court participant, there are 2-3 things which you must keep in mind. Number one is that be aware of the fact that a judge has to hear, say, 40 to 50 matters in a day. But you as a counsel, when you're preparing for your case, you would know all the intricacies, the nitty-gritties of your case. So you are the master of the facts of your case. The judge would not know your facts as well as you would be knowing. So therefore, it is very important that whenever you're making a submission before the court, ensure that you proceed in a very chronological manner, in a selective manner. The language is simple so that the facts which you put before the court, they are put in a simple language for everyone to understand. So that the next step is once you've established your facts, you correlate your facts with the law. Because unless and until the facts are established, law cannot as such be applied in air. It has to be correlated with the facts. So always keep that in mind, that facts are stated very carefully and in a simple language and in a concise manner, so that the crux of the issue, see, because the facts, there would be maybe 10 facts of a matter, but then you know, for the purposes of your arguments, what are those material facts, what is the crux of the matter which you really need to put before the court. So ensure that you are aware of the crux of the matter so that you are able to correlate that with the law of the land that way. And of course, my best wishes to all of you, your wonderful students, and I wish you best of luck that tomorrow when you step inside the real courtrooms, you perform really well. And I would say that law is a wonderful profession. It's a dynamic profession, and it opens doors, multiple doors as career choice for any one of you. It could not be only litigation, but there are other fields also. So, and of course, it also makes you a more responsible citizen for the reason, because when you're yourself dealing with law, you wouldn't think in the manner of breaking the law. So best of luck to all of you, and my best wishes to all. God bless.
Grateful, Your Ladyship. And now I would request Justice Amit Sharma to give a piece of advice to the teams. Thank you.
Well, congratulations to you all. Great effort. One can make out that kind of effort and hard work that you put in. It was a delight to hear you all. And adding to what Justice Pushkarna has said, my only advice would be this, that reading a judgment itself is an art. And the precedent of a particular case is always with relation to the facts of those cases, the context of the matter. Don't take it from a head note, and say that what you have to say. As I said, it's an interesting read, and you'll learn much more. It's a long process. I mean, it's a process which takes time, but it's the most important thing will be that it will come to your use in your profession. That sometimes what happens on the criminal side, we pick up a judgment. If we don't go through the facts, probably the head note would say something else, and the final analysis would be something else, which would actually go against your own case. So reading a judgment is very, very important, and make sure that when you read and you apply a particular precedent, it has some sort of similarity in the context that you are using it in the facts of your case. Wish you all the very best. Hope to see you guys soon in court. Yeah.
Thank you very much, Justice Amit Sharma. I would request Shri Balbir Singh sir to kindly address the team and give a piece of advice.
Thank you. I think all of you were very well prepared. I would say a great job done. But few practical advice I would give as a lawyer. And since the other two co-panelist judges are actually judges, the most important is know your judges. You had a criminal proposition and you had one very solid judge who's from the criminal background, the prosecution side, and the one judge on the bench, and the third is not so well versed with the criminal laws from the commercial side. So know your judges first. That's one very important part. And tread your path. You know that who's going to ask what kind of a question is an extremely practical thing you should know. Second, catch the hints. And in this particular event, I'm not sure, and this is more for defense counsel. Two questions came from the judges saying that the prosecutrix and the other juvenile were from the same area. They were living in the same locality. Another question was whether they had any past history of relationship. On one, there was a statement of fact. The finding was that they were from the same area. On the second aspect, there was no factual background given to you whether they had any past history or not. So there was a vacuum of that fact available in your case. You could have played around that, and you had quoted certain judgment on the consensual angle, and you could have built that angle, a defense side, because you knew that you had a hard case to plead. Because 228 says that there's a presumption by the judge. So therefore, you were playing against a very hard case because discharge at this stage would be very difficult. So therefore, you should have been innovative on that aspect. You should have either, if the statement of fact was not given to you, you could have presumed that there was some angle of a historical relationship between the two juveniles, the prosecutrix and the other who's claiming to be juvenile of the same age. So that would have turned your case to a different angle. These questions were asked. So therefore, you need to think on your feet when you are in a court, that pick up these instances where there is no fact available, try to fill that fact. And practically in your case, you could have gone back to the Moot organizer and could have asked the question on this angle saying there is a vacuum in this fact. What is the background? That's a freedom available to you. So that's a second advice, that you need to think on feet, catch the clues given by the court. And third is, I think, when you are against in a weak case against a formidable opposition, pick up your best points. Now, 53A was very solid point to you. You could have developed more. So instead of being generic all around, spread over, picking up your instances, pick up your best 3-4 points, hammer those points, because you are in a difficult spot. So find your best space, argue on your best space, and try to stay in that area, because that is going to take you out of a difficult spot. So all this requires that once, of course, you have gone through a very deep study, you're very young lawyers. I could see that you were very well prepared. So these 2-3 instances from my side these are practical advantages you can draw from somebody's experience. But as I said, the most important would be when you enter the court, you must know your judges, before whom you're going. You're going through, before the very bright judges who have got a very solid experience in those areas. And then you mold your arguments according and pick up the hints in the courts. I think these are the advice from my side. And all the very best. I can see that you're very hardworking people, and I'm sure you have a great future ahead. Thank you.
Thank you, sir. Thank you, Justice Pushparna ma'am, Justice Amit Sharma. It was a pleasure hosting this competition. Now, I would like to call upon Sanjay Podar sir, Senior Advocate, Delhi High Court, to give a vote of thanks to our honorable judges.
hours they have spent time.
I welcome.
Sorry for keeping everyone waiting.
I welcome Shri Sanjay Podar, sir, Senior Advocate, Delhi High Court. Sir, please address the judges and give vote of thanks.
Namaskar to everyone.
Namaskar.
I, on behalf of Adhivakta Parishad Delhi High Court Unit, our honorable judges, Honorable Madam Mini Puskarna, Judge Delhi High Court, Honorable Mr. Justice Amit Sharma, Honorable Judge Delhi High Court, Dr. Balbir Singh, Learned Additional Solicitor General for India, for accepting our invite to judge the semi-final round of 3rd National Virtual Criminal Moot Court competition being organized by Adhivakta Parishad Delhi High Court Unit. We are grateful to our honorable judges who have spent time, even though today is a holiday. In their busy schedule, they have taken out some time for grooming our students. We are thankful to all the judges who have spent time in this behalf. I congratulate both the teams for participating and contesting the litigation in this moot court. They have been groomed by the honorable judges, and the advice given by the honorable judges are very helpful, not only to the students, but to the members of the Adhivakta Parishad, and which they should keep in mind while joining the practice. I congratulate the students for their effort and performance. However, only one team will be selected for final round. I wish them best of luck. That doesn't mean that the losing team has not performed well. They have also performed well, and they have to keep this spirit alive. Today they might not have been selected, but in the next competition they will certainly be doing well. I wish them also good luck. Thank you very much, honorable judges and the students and my team who has relentlessly worked during this period to make the competition successful. Thank you, everyone. Thank you very much. Namaskar.
Thank you, brothers. Thank you.
Thank you, Shri Sanjay Podar, sir. Now I would request the teams to leave the meeting. Thank you.
Marks are there.
I would request the judges to discuss about the marks.
Yes, but they're still not left. I can still see the participants.